Welcome to Agenda Alexandria. I'd like to thank you all very much for coming out this evening. We have an excellent program planned for this evening. It's called Loan Sharks or Lenders of Last Resort. So I want to introduce our panelists who have come this evening. I want to start at your left, my right, at the far end. Jack Murray is president of Fix Media, an Alexandria-based marketing firm that helps people who need money find online lenders. A native of Alexandria, he currently lives in Lorton. He has a bachelor's of arts in communications from the University of Dayton. Before co-founding Fix Media, he worked in sales and management for CBS Radio and Radio 1. Then we have Mr. Joel Bassam here, is Director of Marketing for Eastern's Automotive Group, the used car dealer that specializes in the subprime auto loan market, where your job is your credit. A native of Springfield, Virginia, he currently lives in Reston. He has a Bachelor of Science degree in Business Administration from the University of Mary Washington. Then we have, to my left here, Aaron Whitty, who is Assistant Attorney General in the Predatory Lending Unit of the Consumer Finance Protection Section. A native of Vineland, New Jersey, she currently lives in Vienna, Virginia. She has a Bachelor of Arts in Law and Justice from Rowan University and a Juris Doctorate from George Mason University. Before joining the Virginia Attorney General's office, she worked at Serval, Isaacs, and Levy, doing consumer protection litigation focused on used car dealers and predatory lenders. Then at the far end of the stage here is Jay Spear, Executive Director of the Virginia Poverty Law Center, a nonprofit organization in Richmond that runs a predatory lending hotline and advocates for policy change in the General Assembly. A native of Philadelphia, he was raised in Pittsburgh and St. Louis and has lived in Virginia since 1976. He has a Bachelor of Arts in Foreign Affairs from the University of Virginia and a Juris Doctorate from Marshall With Law School of Law at the College of William and Mary. Okay, so I want to start our discussion here by looking at the title, Loan Sharks or Lenders of Last Resort. There is a debate about what to call these kinds of loans. I want to start with Jay Spear. The term predatory loan is loaded, right? It's a loaded term. When we talk about loans, you know, people need money, right? What exactly is predatory about some loans that are given in Virginia?
Well, to me, the difference between in loan sharking and lending is whether you assess the person's ability to repay the loan. And if you do not do that, if you are engaging in loan sharking. And the reason you give people money when you're a loan shark is that you have a certain way of getting it back. Everybody thinks of loan sharking as the guy who breaks your leg when you don't repay it. But there are also loan sharks who loan money knowing that they can either take the money out of your bank account or garnish your wages or whatever it might be, or hold your paycheck. That's the difference. And a lender is somebody who assesses your ability to repay, and they look at your credit, and if you have the ability to repay the loan, they make you the loan, and it's a mutually beneficial relationship.
Well, I will turn the same question over to Jack Murray on the other end of the stage here, who is, I get the impression from speaking to you earlier that your company is sort of like an Expedia for online loans, right? Correct. So, you know, the online lending world is viewed by many as the Wild West. We'll actually later get into a specific case where a judge called it the Wild West. What's your reaction to what Mr. Spear just said about many of the loans in this sphere as being predatory? Are they predatory?
Well, I think he brings up some excellent points. I also believe, especially with the lenders that we work with, I'm not sure that many of them would be willing to loan money to somebody that didn't have the ability to repay, because obviously if you lend somebody money, you'd like to get it back. In the particular kind of space that we're in, which are short-term, smaller dollar loans, they're unsecured. So they're not tied to any real estate or any property. And so the ability, there's not going to be any kind of, or there typically wouldn't be any kind of over-the-top ways to get the money back. There wouldn't be a lawsuit, et cetera. So these folks that come to our site are looking for short-term loans, and the lenders would only lend to them if they had the ability to repay. But he's very correct in that there are a lot of people out there in the wild, wild west. The internet is a very interesting and awesome and dangerous thing. And to understand when you're online, whether you're booking a hotel through a third-party site, booking an airline, a vacation, finding a loan, finding a mortgage. It's very important that the site that you're on is a legitimate site and will match you with a legitimate service partner. So I do agree that there are bad people out there, and a lot of them are operating from other countries that can put up a website and trick somebody into applying for a loan without really any interest in giving them a loan or making it a loan that they could repay.
So you just said two things that I know Aaron Whitty wants to talk about, which is one of them is the Wild West, and the other is people from other countries making a loan, although in the one case that she's been working on involving Allied Credit, Net Credit, there are lenders from other states that are not following Virginia law. Aaron, talk a little bit about this lawsuit that the Attorney General's office and you have been working on involving this company. This is a Fairfax County court case involving a company that's based out of Chicago, right?
Yes, that's right.
Explain what this case is all about and your involvement in it.
Sure. So we filed a lawsuit against a company called Net Credit. Net Credit is an internet lender. They don't have any physical locations in Virginia. They don't have a storefront here. They're based in Chicago, Illinois. And Net Credit is not licensed as a consumer finance lender in Virginia. They're unlicensed. And they make loans to residents of Virginia. I think that they've made about 40,000 loans in Virginia over about a 6-year time period. So we filed a lawsuit against Net Credit because we believe that they should be complying with Virginia's lending laws. There are certain exceptions to the cap on usury in Virginia, which is 12% interest. And our position is that Net Credit doesn't qualify for an exception to that limit, that they're supposed to be lending at 12% maximum. What Net Credit does in their contracts with Virginians is says, we're going to apply Utah law to your contract. Utah law doesn't have a cap on the interest rate that can be charged on consumer loans. So Net Credit has chosen to affiliate itself with Utah so that it can make loans to consumers at unregulated rates of interest. I think that the highest rates of interest that Net Credit was charging were 155%.
On that note, I want to go to Eastern's Automotive, where your job is your credit. Now, one thing that's really fascinating is that expression, where your job is your credit, is so ubiquitous. You've probably heard that so many times that you don't know that Eastern's actually coined that phrase, right? You guys actually invented this and trademarked, and it the part of the market that you're really have specialized in is the subprime market, right? Explain what that means.
Oh, I'm sorry. Yeah. So I would say that when our company started 30 years ago to the day, the concept was simple. The people who were in the subprime market didn't have somewhere to go to get a quality car. They were stuck dealing with people who potentially didn't have their best interests at heart, selling older vehicles and things like that. There was a need there that we felt we could serve. So where your job's your credit was, we felt a very simple way of letting people know that we wanted to deal with you. If you had less than perfect credit, but you had steady income, there was an option out there available for you that would get you a reliable transportation. That was always the point of that marketing phrase that really became kind of famous for our jingle and things like that most people from DC would know. But the concept was simple. It's like you mentioned before, a mutually beneficial transaction where a customer who is willing to potentially pay a higher interest rate, who doesn't have another option to get a reliable car, this is a place where you can come and do that.
Okay, so I want to go through two housekeeping things really quick and then return to our discussion. One is, for the panelists, I want this to be a discussion, so feel free to chime in or grab the microphone out of my hand, in your case, and react to anything that you hear from the other panelists. The other is for the audience, which is at the center of your table, you'll find some sticky notes. Frank Fannin, if you could wave those around in the area. So if you want to write your questions down, Mr. Fannin will come around and grab them and bring them up to me here on the stage, and we will ask your questions. So I want to open it up to the panel and ask an open question, which is, what, if anything, should be done about this? So there have been several proposals here for potential remedies at the state and local level that I'd be interested in focusing on. One at the Virginia General Assembly, the other at the City Council level. Let's actually start with the City Council level. So one thing that Fairfax has done that Alexandria has not done is going after payday lenders and car title lenders by making zoning changes that limit where they can put up their business, and then also making them only establish themselves in revitalization zones. So Fairfax is actually way more difficult to open up, like a Loan Max, for example, or a Title Max. It's way more difficult in Fairfax County than it is in Alexandria, because the Fairfax County Board of Supervisors has taken this action that Alexandria has not. Mr. Spear, I know that your group was involved in lobbying the Fairfax County Board of Supervisors in favor of that. Talk a little bit about how that came about and why that might be replicated elsewhere, including in Alexandria.
Well, most cities and counties find that the payday lenders and the car title lenders bring down the neighborhood immediately because it attracts. Most cities and counties feel like, you know, I should be able to speak up. My father-in-law is 96 and I have to talk loud all the time, so I'm used to that. But most cities and counties find that the payday lenders and the car title loan stores drag neighborhoods down. I mean, they come in and they attract other businesses like the Jackson Hewitts and other places that take people's money. And you drain money out of the economy, out of the local economy. And most of these are national businesses located elsewhere. And you take money out of the local economy that could be spent at the neighborhood stores. And it goes to wealthy people who own these businesses elsewhere. So it's not good for the local economy.
And I want to add to that, because you brought up a great question, is, all right, so what do we do? And you talked about what the city of Alexandria is looking to do, what Fairfax County has done, and I think those are all great first steps. But what these discussions typically don't focus on, and maybe they should, is all these companies open up, and once again, I'm not a lender. I would never be into lending, mostly because I don't have enough money to lend anybody. But I own a marketing firm that works with lenders, so I know a little bit about their business. But I do know this: these stores don't open up unless there's a need for them. These rich people don't open a store in the worst neighborhood to lose money. And the consumers that use these products continuously use the products. We've got a bigger problem here, and it's how do we help those consumers find an affordable loan when they need to borrow $500 for a car repair? Because without that car repair, they can't go to work tomorrow. And if they can't go to work tomorrow, they lose their job. And if they lose their job, now they got real money issues. That consumer, and I've seen it because I read all the reports and I see the feedback, that consumer would rather borrow $500 and pay it back in 2 weeks when that consumer got his paycheck and pay $550 back for that $500 loan. Because that $50 saved his job, it might have saved his daycare for his kids. It was an emergency expense that Bank of America ain't gonna help him with. If he walked into SunTrust or he walked into any of those banks, they said, well, you don't have any, we're not giving you a loan. Those stores are there because they serve a purpose. When I told you about the guy that goes and borrows $500 and he has to pay back $550 in 2 weeks, Frank, you're in the mortgage business. I don't know what that APR is, but it's got to be 240%. It sounds horrible. It sounds predatory. But you talk to that consumer, taking that store away or taking that company away online did not help that consumer get into a better spot. It took a resource away from that consumer without giving the consumer other options. I'll be the first person to tell you we should come up with other options. I just read a report. The FDIC has literally just sent out to the big banks a demand to talk about what can you do to start providing small dollar loans. The minute you can get a small dollar loan at Wells Fargo is the minute all those payday loan stores close. But the issue is, it's a lot easier to go after the corner payday store than it is to go after these multi-gazillion dollar banks. And so I agree, there is an issue, but the issue we need to look at, in my opinion, is we have not solved how do we get rid of the need for that small dollar finances for folks that don't have credit, and we haven't figured that out yet.
And I would just say one thing too. I agree with you completely, but I think there was an important distinction that he made. He said take the money out. And I think if these loans are issued in a way where there's no the difference between lending and loaning, like you were saying before, if there's no intention of looking at whether that person can pay it back or not, that's the distinction that isn't being made by some of these companies. And I think that that's the larger argument, is should there be a distinction made, or does that go down that rabbit hole? because the idea is not putting someone into a debt spiral where they can't get out of it if they're rolling that loan over and they're
Correct.
taking out another loan.
Totally
you don't want to
agree.
get stuck in that kind of situation.
I couldn't agree with you
$50 may not sound like a lot, but what's to say that customer's not going to be in the same position 2 weeks from now, where they're just going to make another $50, another $50, and then the interest builds and builds and builds.
Well, and that's an excellent point. And I think a lot of that comes to, and these companies have not done a good job of it, right? Which is full disclosure. Here's what happens if you don't pay this back. Here's what happens if you only pay the minimum. The disclosures, and I feel that because of some of the work that you guys have done, the disclosures and the truth in lending laws and a lot of these things have gotten a lot better, because it's despicable how some of these folks would give loans. I mean, despicable. They were literally, some of these companies would give loans intentionally to deceive the person. That's crazy. Anyone agrees that those people should be out of business. So there's a way to do it the right way to serve a need, but the bigger discussion is, how do we prevent that need?
So what you described with the person borrowing $500 and paying back $50 sounds great, except it doesn't work that way.
Exactly.
It's absolutely designed to work so that you continuously have to come back and borrow and borrow and borrow. What do you think happens when the guy comes back and pays $550? How's he going to pay his rent? He has to get another loan. And that's what all these loans are designed, their so-called loans are designed to do, is to trap you into a debt. That's why we refer to them as debt traps, so that you keep continuously spiral this. We had a case we brought to the Virginia Supreme Court where a lady used her Social Security check to get loans every single month for 3 straight years, 36 straight loans. And that is their best customers. They love customers like that. That's what this is designed to do. When you don't assess, whenever you see a store that says no credit check or buy here, pay here, those folks are not interested in whether you can repay the loan. They're interested in getting you in so that you can't get out. And when people call us, my colleague Dana is here. Dana and I have talked to hundreds of people over the last few years that are stuck in payday and car title and internet loans. And they all say pretty much the same thing, that I'm stuck. How do I get out? That's what they call us for. They want to get out. It seemed like a good idea. It's a friend of mine said it's like giving poisoned food to a starving person. Of course, that food's great when you first get it, but the long-term effects is really bad. And when you have a bill to pay, you can go down and get that $500. You feel great for a while, but it won't be long before you're going to run into big problems.
Yeah, and
don't forget, what did we do before we had these? Why do we suddenly need payday and car title lenders everywhere? We didn't have any of these places 20 years ago. When I first started practicing law, there was no such thing. Why did we suddenly need them? They create their own demand by churning people. Their entire, something like 80 or 90% of their business is just repeat customers. And it's not all these people that need it, it's the same people getting the loans over and over.
And the $50 to borrow $500 is a pretty pristine example. In the net credit lawsuit that we filed, the example that we attached in our lawsuit was a consumer, I think, who borrowed $2,500 and had to repay $6,000. So that's a pretty isolated example. But the reality is that many lenders who operate in this sphere are not offering this $50 to borrow $500. It's 150% interest. It's annual interest that accrues daily at 273%.
So I don't disagree with what you're saying. Once again, I'm on the marketing side. I own an ad agency that represents lenders. So I don't know the intricacies of that, but I will tell you this for a fact. No matter what you guys say on that side of the room is going to be the horror stories, which it should be. No matter what I say on this side of the room is going to be the way that it saves someone's job. There are those stories. There are those stories. I think we could both honestly agree on that. There are people, and you can look at even the Pew Charitable Trust study, which is they're a very, I would say they're similar to the Virginia Poverty Law Center, that they're very big consumer advocates.
What was the title of that study?
I'm just reading, I haven't even finished what I was going to say, that in Pew's research, in their most recent study that came out, I don't know what the percentage is, and it goes back to what you had asked earlier. I think it's close to 40% of Americans, and I still find myself in a position where I'm talking about lending, and I'm not a lender, but 40% of Americans can't come up with an emergency payment of $500 for an emergency expense. Let's say that's true or not true, and let's say these issues don't even exist. But my question really to the panel or to anybody would be, what do we do to help those folks find that money that they need or give them access to credit? I think that's a big question that would be a really neat topic.
And I don't think anyone disagrees that there's a need for credit. I don't think anyone disagrees that someone may need a loan. I believe, and Jay can correct me if I'm wrong, but the vast majority of consumers who obtain loans from places like this don't get them because of an unexpected expense, something that came up suddenly, like a $500 car repair. These are consumers who can't pay their bills. This is someone who can't pay rent, they can't pay electric. This is a longer problem than just an unexpected $500 expense. So these people may need access to credit, they may need money, but what they don't need is more debt and more oppressive debt in the form of a 273% interest loan.
So one thing Jay Spear said earlier that I'd like to circle back around to is that many of these loans are designed to have consumers take more than one. So there was a time when the payday lending industry in Virginia had gone to what some people believed was way out of control because people were taking multiple loans and taking out loans to pay the loans they had previously paid, right? So, so the General Assembly actually ended up passing a reform measure that hopefully we can talk about now, that really cut down on payday lending in Virginia. Payday lending today is a shadow of what it was a decade ago. So in 2007, a decade ago, there were 3.5 million payday loans. Today, there are less than 500,000. So there's a huge decline in the number of payday lending. The total dollar amount of the payday lending industry, the loans that were given out a decade ago, that was $1.4 billion, billion with a B. Now it's $122 million. So Jay Spear, talk about why the payday lending industry is a shadow of what it used to be a decade ago.
For two main reasons. They actually did not do much on the interest rate. You can still, the average payday loan is still over 220% in Virginia, but yet it's
254.
Okay, thank you. And the two main reasons it dropped is because, number one, they said you can only get one payday loan at a time. People were going from, what typically happens when you get these unaffordable loans is you get the second loan to pay the first loan, the third loan to pay the second loan, and on and on and on. We had one person who had 18 loans at the same time. So the General Assembly said you can only have one at a time. The second thing they did, and remember, they did not really cut the interest rate. The second thing they did is said you have to give people 2 pay periods to repay. And what this did was cut their favorite customer, who is the person on Social Security, could only get 6 loans a year instead of 12, because you have to give them 2 months to repay instead of 1. And so that took away like one of their best customers. And so that's what a lot of it led to a real drop in the industry because they shifted to other things, or a lot of them went out of business. But that's, again, that proves my point. That's the whole point of their business, is to churn people. And when you took that away, even though you can still charge high interest, it dropped precipitously.
Well, I think there's also now installment type loans. So what Net Credit has been accused of would be considered an installment loan and not necessarily a payday loan. So there could be a reclassification of some of these loans. My guess would be that those numbers haven't decreased as much as you think they have. The type of loan may have changed. The lenders might be a little bit ahead in terms of going, instead of the standard pay me back in 2 weeks, quote, payday loan, they extend it to a longer term installment loan. But you're right, the CFPB, the Consumer Financial Protection Bureau, just came out with a law that's going into effect that does limit the amount of loans you can get in a year, which I think is great. I also, with all due respect, the idea that people on welfare or benefits are these companies' best clients, that's just absolutely shocking to me. On the marketing side, I work with lenders. Not one of my lenders would even accept a lead that has someone on benefits. So I'm not sure who those lenders are. I'm not disputing that they're out there, but that's terrible. I've never heard of such a thing. So I don't know who they are, but that's not good, obviously.
Well, actually, you just said something that Aaron might want to touch on, which is that you were talking about the specific kind of loan that's involved here is not with the net credit case, which this is the case that's in the Fairfax County Circuit Court. So it is not a payday lending case. This is not a car title lending case. It's something called installment loans, which some people, I think perhaps even including the Attorney General of Virginia, thinks is a loophole. They call it the installment loan loophole. Aaron, what does that mean?
Well, installment loans are a little bit different than open-end loans, which is a much bigger loophole with the Allied title lending case that we discussed before. But with
I'm sorry, I messed that up. So
Okay.
the Allied is a
Allied is open-end. That's a different
open-end line of
loophole.
credit versus installment credit.
But
Okay,
that
please
can-
please
yeah.
walk us through these.
So this can dovetail a little bit nicely about the discussion about payday loans, because we have another case in Richmond Circuit Court pending against a company called Allied Cash Advance. I think Michael and I looked it up, I think they have a location in Alexandria on Richmond Highway. I know they have one in Manassas, but this company is an open-end credit lender. But the reason that this dovetails from payday lending is because they used to be a payday lender. And when the restrictions changed and they became more regulated, they just changed their business model and they became an open-end lender. We call this a loophole because unlike payday lenders, unlike car title lenders, and certain installment lenders, consumer finance lenders, open-end lenders are a loophole because they're unregulated. There is not 30 statutes that govern their conduct. They don't have to get a license from the State Corporation Commission's Bureau of Financial Institutions. They can essentially just make a loan. The company that we filed a lawsuit against, which is Allied, was making loans at 273% interest annually. Open-end loans it's called a line of credit, so it's sort of like a credit card in that it's open-end. There's really no definite end. This is different than an installment loan, which is like when you borrow money to pay for a car and there's a definite 2-year time period on that loan. So open-end loans could exist in perpetuity. As long as you have an open balance, you are accruing interest on that loan. So someone who borrowed the $500 for a car repair might end up owing over $2,500 by the time their loan is said and done with. Again, this is a loophole that we think needs to be fixed by the legislature. They're a little bit different than installment lenders, but open-end just doesn't have any oversight by Bureau of Financial Institutions over their conduct. They have very few rules that apply to what they do, and they actually don't even have an interest rate cap on the loans that they make to consumers. The law says that whatever the parties agree to, they can charge it. There's a few restrictions, and our position is that Allied violated the one rule that governs their conduct with consumers, and that affects their loan product for a 4-year time period. Sorry if that's complicated.
I want to shift a little bit and talk about subprime auto loans. So people in this room may be familiar with the subprime mortgage crisis that happened a decade ago that tanked our economy. There are lots of people now who are concerned about a subprime lending bubble with the auto loan market, that there are so many of them and that they are being given to people who can't pay them back, and that they are being packaged and sold as securities to investors in much the same way that happened with the mortgage crisis. So I'll ask Joel, I'll hand him the microphone and ask him the question, is there a bubble in the subprime auto lending market right now?
Yes. Next question. No. Yes, I would absolutely say that we're building towards a bubble in the auto space, 100%, for multiple reasons. One, and not necessarily the subprime yet, but working its way kind of down that natural progression would be the extension of terms. 5 years ago, the 60 months seemed crazy. Now 72 month became the norm. Then 75 month became the norm. Now you can get 84-month loans and even 96-month loans with some credit unions. The concept of paying for a depreciating asset over that long of a time, especially one that's already begun to depreciate in the used space, is just going to put someone in that position where if they do want out of that loan at any point, they're not going to be in a positive equity position, meaning that the value of the asset that they loaned against is going to be less than what the value of that loan, the balance of that the loan still remains. And it's the same kind of thing. You end up rolling that into your next auto loan and rolling and rolling and rolling. It's the same spiral that's being discussed here. And that longer term is getting pushed further and further down the subprime spectrum, where right now it's only available for prime. Additionally, while auto loans are considered secure, I would almost argue that they are not in a way, because one, unlike a house that is for a majority of time an appreciating asset, until markets crash, cars are guaranteed to be a depreciating asset. And on top of that, it is one of the most insane things that you can walk into any dealership and say, I want to buy this car that costs $10,000, and I want a loan for $12,000 for the value of that car that's worth 10. So that's the loan to value ratio. It's acceptable to go greater than the value of the asset at the initial point of the loan. You can only imagine what that does down the pipeline. It increases interest rates. It increases the chance of that person being in a negative equity position. Average car ownership in this country hasn't changed. It's still at 33 to 34 months. And if you do the math, terms increase, average ownership stays the same. As income is it hasn't really increased that much when compared to the inflation and things like that. So you just get stuck in the same kind of spiral where you're dealing with negative equity, loan after loan after loan.
So we have a question from the audience, which is, what would you recommend the General Assembly do to address this issue in 2019? So I want to sharpen that question just a tad by talking about online loans specifically. So this is really the Wild West, right? So all those rules and regulations that exist about car title loans, that exist about payday loans, they do not exist for online loans. It really is open to what these companies want to do. So I want to ask the question to Jay Spear, but I also want to mention that one of the key lobbying forces in Richmond that lobbies very heavily is the Online Lenders Alliance, which Jack is a member of, right?
Correct.
So Jay, what would you like to see happen with online loans in the next General Assembly, and get your reaction to what he's proposing?
So right now, the loans that we see online are two types of loans. They're the installment loans and they're the open-end credit loans. The installment loans, anybody making the loan over the internet that charges more than 12% is making an illegal loan. And so that's why the Attorney General is suing some of these folks. That's why we sue some of these people. But what happened last year was there was a bill introduced to license internet lenders so that they can make loans lawfully in Virginia. And there are, in fact, there's something called the Marketplace Lenders Association who does make loans over the internet at less than 36%, which would probably be good loans for people. But there's the Online Lenders Association, many of whom, I've counted at least 10 types of loans that charge over 700% interest. And that's not a useful type of loan. The other thing, though, that has to change is under Virginia law, if you make they want to come under the Consumer Finance Act. And the Consumer Finance Act, if you make a loan for $2,500 or less, it's capped at 36%. And we have a lot of companies in Virginia called consumer finance companies that have been making these types of loans, and they're responsible lenders that assess people's ability to repay. The problem is, though, if you make a loan for over $2,500, there's no cap at all. And that's what the online lenders want to do, is they want to get licensed, they want to make loans over $2,500, they want to keep charging 500, 600, 700% interest. So there were two bills last year. One was to allow the licensing, and then there was another bill that we were in favor of, which would cap all loans at 36% under the Consumer Finance Act. And we think it's fine if the internet lenders make loans under the Consumer Finance Act, get licensed, and if they're all capped at 36%. But we don't want them to come in and have no cap and just be licensed to do what they're already doing, which is to destroy a lot of people's lives, basically.
So you brought up some very interesting points there. First of all, I will tell you flat out, any law that has 12% interest rates for online loans, it won't work for not only, those companies would all go out of business. So that'd be done. Not only that, the companies that you mentioned that do provide online loans for under 36% are providing online loans at very good rates to highly qualified individuals. If many of us in this room right now applied online for a loan, you could get an online loan for probably 12%, 8%. I probably got great credit, probably own a house or some real estate, no problem. The Online Lenders Alliance, who I'm a member of, represents a lot of lenders that aren't necessarily playing in that piece. They're playing in a shorter term loan that are unsecured. They're not secured against anything. some of them end up with 20% defaults, just not paying. Do the math. If you do a lot of $500 and $1,000 loans, and 20% of them aren't paying you back at all, you're out of business with a 36% APR, like instantly, which is fine. Let's say we do it. We all vote for it. We have a 36% hard rate cap or 12%, whatever it is in the state of Virginia. And so what'll happen is this. The companies like Enova, Net Credit, they'll say, we're done. And they're actually a publicly traded company that has a decent reputation in the space. They're not some overseas company trying to rip off, they actually have 24-hour customer service. If you had a question, they'll actually answer it. They'll work with you. Get rid of all those companies, the ones that are trying to do things the right way, and say, you're not allowed to do business in Virginia. Anyone can spin up a website. Who do you think is going to be loaning to Virginians online? There's going to be some really bad people, So we definitely need some regulation. We need people on the same page. But we've got to also understand there's a need, a huge need. I think you mentioned over 44,000 people just in net credit from Virginia took out a loan. That's net credit. I don't know what the number is from Virginians totally that have taken a loan online. But if it's just 47,000 from net credit, it's got to be in the, 500,000 to 1 million consumers at least. This is a real issue. We still haven't figured out what do we do for them to give them another opportunity or a better alternative. We could pass all these laws. I'll vote for them. But without another alternative, what do they turn to? The state of Georgia passed some very serious laws on, quote, payday lending. Their personal bankruptcies went up almost 10%. The bounce checks in the state went up 13%. The bounce checks is a thing we never talk about. I'm telling you right now, you write out 5 checks. Let's say you have $1,000 in your account. You write out 5 checks. And that big one of $1,100 somehow got to the bank first. And then you bounce 4 more checks. One for Domino's Pizza for $15. One to your Little League fundraiser for $25. That bank hits you for every single bounce check for $35. What's a $35 fee on a bounce check for $15? I don't know the percentage on that. That's a high APR. That sounds predatory to me. That does. But no one talks about that. No one talks about what do we do about the banks, the big banks with the big money that rip off people every time they take an ATM deposit. You take out $10, they charge you $3.50. That's 35% in one transaction. Well, let's do the APR on that. The percentages sound really, really scary. And the percentages are real. I'm not discounting what you're saying. They don't tell the full story. They don't tell the full story. Virginia has a huge need for the product. That's why the product's here. We've got to find a way so Virginians don't have the need for the product. And I'd love to be a part of that panel.
They create their own demand. There are a whole lot of states that do not allow this type of lending. In fact, they call themselves payday freelandia, and it covers 90 million people in the United States. Are they begging for payday loans? No. In North Carolina, they had payday lending. It's sunsetted, and it's never come back because there is no demand for it.
Yes.
They create their own demand. People have always, when you have somebody who their expenses outweigh their income, a loan at 300% interest is not the solution. They do have needs, but this is not the solution. It seems to be a solution to them. And he brings up the thing about overdrawing accounts. That's what internet loans do to you. They will overdraw your account. Something like 35% of the people who get internet loans overdraw their accounts. They say they're not secured, but what they do is when you get the loan, you agree to let them take their payments out of your account. And so they get paid before anybody else. And people call me because they can't pay their rent because the internet lender took all the money out of their account, and then they're scared to death about what to do about it. So to suggest that the solution to people not having enough income or having too much expenses is a 300% loan doesn't make any sense. And again, remember, we had no payday lending in this state 20 years ago, yet somehow people survived. And remember, they create their own demand by churning people over and over again.
One of the key issues here, and Jack brought it up, is the ability to repay. So there's a big debate about whether or not these lenders take the time and effort to figure out if these people can actually repay the loan, or if they know the lender can't pay the loan when they give them the money. And I want to circle back around to the subprime auto lending market, because there's a key player in this, Santander, who the Massachusetts Attorney General is going after as giving $22 million worth of loans to 2,000 car buyers. And the Massachusetts Attorney General says there is no reasonable basis to believe that these people could pay them back, right? So I want to ask Joel about that. Talk about in this space of subprime auto lending, how many of these loans are going to people who there's no effort to find out whether or not they can pay them back?
So in our case, and most dealerships who I assume they're good practitioners who actually use third-party lenders, 0% of them are not considered that, because hard credit checks are a requirement to be part of this. OFAC checks and making sure the person is who they say is a requirement for at least our business in order to do that. And most third-party financing partners are going to require that. There are other dealerships who are, the We Finance, the Buy Here, Pay Here's that we mentioned, are very similar to this space in the sense that it's much less regulated. They don't necessarily need to run a credit check. In fact, they might advertise that they don't. And that's the big differentiator between those people. So we always run credit checks, and it's always going to be a factor. It's not a guarantee. We're not a guaranteed approval. That's impossible in space, because you can't look at 100 people down the street and say every single one of those persons will be able to pay a $20,000 loan back to you over a period of time. You have to look into their past, their history, their ability to pay, their debt to income ratio. All those things are important factors to understand whether the person's going to be able to make that loan. For a good practitioner, it should be a mutual beneficial transaction. I know he mentioned that before. That's a great way of putting it. The customer should be able to have an asset that's reliable. They should be able to make that payment back, and it should also report to their credit and begin to build that credit score up. And for our business, we call that graduating, moving on to the next. Graduating to a lower interest rate is a huge step in that customer's next step. The only way to do that is by making payments on time.
What about the Santanders of the world? Is that concerned?
I mean, they're always so. Yes, I mean, it's a concern in that sense, but a good lender is vested in the interest of their portfolio. So we don't want to underwrite or provide loans to consumers on our behalf that's going to be underwritten by another bank that they're not going to perform. It doesn't. I don't want a customer not to be able to pay their loan, because it hurts my business, because it'll hurt my portfolio of business with that bank. It's not a good thing to have cars that are repoed and things like that. That's a bad thing for everybody involved. Nobody wants that, unless you're potentially predatory in the sense that you want to sell that car again at a higher interest rate. But that's not the world that I live in. That's not the world that most banks live in.
Yeah, so the dealers that I'm familiar with will sell you a $10,000 car, and after a while you can't afford the payments, so they repossess the car, they sell the car for $500, and then they sue you for $9,500. Then they sell the car to somebody else, and they do the same thing. And it goes on and on like that, and that's how they make their money. They often have 3 or 4 people paying for the same car, and what they do is they sue you, then they garnish your wages and they garnish your bank account, and that's how they get paid. Credit Acceptance Corporation is famous for that. They file lots and lots of lawsuits in Virginia, and that is their business model. And unfortunately, it's miserable for people who go through that, because not only do they lose the car when it gets repossessed, they probably lose their job, and now they're having their bank account or their wages garnished. And then they can't get another loan from a decent place, and so it becomes a bad spiral for them.
So we are located on the west end of Alexandria near Landmark Mall, what used to be Landmark Mall, where there was a store called Sears, which for many years you could buy a refrigerator, an appliance, something really expensive at Sears, and you could pay for it over a period of time with something called an open-end line of credit. In recent years, businesses that are not Sears have been using that model to make loans, and in fact it's one of these companies called Allied that the Attorney General's office is now going after for making what they consider illegal open-end lines of credit. The company says they're open-end lines of credit, but the Attorney General says, well, wait a second, we're not really sure that's the case. Talk a little bit about the Allied case in Richmond and how that might impact Virginia consumers.
So the Allied title lending case is what I mentioned before. They're using this loophole in the law because there's no cap on the interest rate and there's essentially no regulation over their conduct. Payday lenders, car title lenders, even consumer finance lenders have to file a report with the SEC. They have to say how many loans they've been making each year, if the loans are secured, how many cars they've repossessed, how many lawsuits they've filed against consumers. Open-end lenders have to do none of that. The only real rule that applies to open-end lenders is that they can't charge a finance charge during an initial grace period. So they have to give a consumer a certain amount of time to repay the principal balance of the loan before they impose a finance charge. The most common example of a finance charge is interest, but in Allied's case, they were charging what's called an origination fee. And our position is that that is a finance charge. So a consumer would go into an Allied store because, again, they're physically located here. They're not an online lender. A consumer would go in, borrow $1,000, and on that same day, Allied would give them a billing statement that says, all right, you owe us $1,000 plus a $100 origination fee immediately. Our position is that that does not comply with the only rule that open-end lenders have to comply with. Because of the fact that they violated that one provision, our position is that those loans are all now therefore void, and that Allied can't keep any of the money that they've taken from consumers, including interest, principal, fees, anything. That case is still in litigation. We still have to prove our case to the judge. We still have to win, but that's what's going on with that case.
Yeah, and in case you're curious about the geography, so there is an Allied location that is nearby in Fairfax County in the Woodlawn area. You may know the nearby landmark, which is the Roy Rogers right across the street. The question from the audience, Aaron, are there other states that have these open-end lines of credit like Utah? Basically, are there other states like Utah, or is Utah an outlier?
So Utah came up in the context of net credit, which is a different kind of loan. Net credit is an installment loan. Allied is open-end. So the Utah example applies to the installment loans. There's no cap on the interest rate for those in Utah. Installment loans are regulated a little bit differently in Virginia, so it's kind of hard to compare those two, like Virginia and Utah. And again, this is complicated, so I'm really sorry if I'm losing you. But there are other states that have open-end loans. I think the biggest problem with Virginia is that we have all these other regulated loans, and that open-end is really just this outlier. I'm not exactly sure why that is, why the law hasn't changed, but there has been legislation that's introduced every year. Every year it's shot down. We're hoping for more changes, but we'll see where that goes. I'm sure other states do have open-end loans, but I can't really speak to, the loopholes in other states and how that relates to the other types of loans in those states.
And Senator Surville brought the bill last year
That's
to
right.
try to regulate the open-end creditors, and he was not able to get it passed.
And the Online Lending Alliance opposed that bill, I believe, right?
They may have, I'm sure they did. I'm not on their lobbying side, I'm a member.
No, I don't think so.
So I want to talk about potential reform. So we talked a little bit about things that might come up in the General Assembly. One thing that could come up at the local level is a proposal that happened here in Alexandria. It didn't go all that far, but it might make a resurgence. Back in the year 2008, there was a member of the General Assembly by the name of Justin Wilson who wanted to crack down on what he considered predatory lending at the time, payday lenders and car title lenders. And he found a way for the local government, the Alexandria city government, to create a new subcategory of B-poll taxes. These are business and professional licenses. And so the city has every legal authority to create this new subcategory specifically for car title lenders and predatory lenders, and then so carve them out from every other sort of financial institution, and then hit them with the highest available tax rate under the law, which was 58 cents for every $100 of gross receipts. As you might imagine, the industry opposed this. They threatened a lawsuit. There was lots of what Wilson calls saber rattling, and so they ended up coming to a resolution where the industry funded a consumer education effort that lasted for 1 or 2 years and is now totally defunct. However, this proposal is kind of still out there in the ether and could, in fact, happen. I spoke to Justin Wilson earlier today about this proposal, and he was telling me that the industry really came out heavy against it and had this army of lawyers, mainly because they were not necessarily really concerned about the damage Alexandria would do, but if it created a precedent, and then you had Loudoun wanted to do the same thing, and Fairfax wanted to do the same thing, and Richmond wanted to do the same thing, it would really cut into them. What do we think, I'll open it up to the panel here, about creating a new subcategory of B-poll taxes for what city officials might consider predatory lending, and then hitting them with the highest available legal tax rate?
The only thing I would say is I'm not sure about that, but we even were sitting at this table before, we couldn't define predatory lending. So who is the person who's holding that bag saying define that and define these lenders as such?
And on top of that, I would say that if taxes get raised on these companies, they do one of two things. They close down or they raise their rates. So it's going to be even more for the consumers. So that 300% is going to be 320%. So I think that, or to your point, we get them out of Alexandria and they go to Arlington. But I don't know that once again, I don't know if that solves the issue, but it puts it in someone else's backyard, I guess.
Well, actually, to answer your question about who defines predatory, in this particular case, if you're talking about the B-poll tax, you wouldn't need to define it because you could just say car title lenders and payday lenders, right? So,
I'm just trying to understand. I'm curious. I'm saying you were going over previous examples, and there were people who have changed the definition of their businesses in order to escape those taxes. So where does those?
Right, but
just
those
so I
are pretty
understand.
common. Like in the Virginia lending laws, those are pretty common terms. So an
Understood.
open-end lender is defined in Title 6.2 of the Virginia Code. So are payday lenders, so are car title lenders. So I think that if you said open-end, installment, consumer finance, payday, title, those would all be defined terms in the code that we could reference back and say which ones are subject to this tax. I think that's a pretty easy problem to fix.
Understood.
The cities and counties around Virginia are frustrated with the General Assembly because they haven't done anything comprehensive about predatory lending. And a few years ago, we went around the state and asked counties and county boards of supervisors and city councils to pass resolutions calling on the General Assembly to put a 36% cap on loans. And we had over 100 of these cities and counties that did this. And if you took a poll, and there have been polls done in Virginia, you'll find that 60-70% of Republicans and Democrats and independents all agree that 36% is a proper interest rate cap. Yet we can't get that done at the General Assembly, and that's why these kinds of things you're seeing coming from the cities and counties is because they're frustrated that the General Assembly won't do what they should do.
And there are plenty of lenders who can make loans at 36%. They are out there. There isn't a need to charge 700% or 500% or 300%. I think that need arises from the desire to make a profit.
question from the audience about licenses. Some of these lenders are required to get a license to offer certain kinds of loans. Other kinds of lenders are not required to get a license. This seems inequitable, right, by definition. Why is it some of these, how have we found ourselves in this position where you need a license to offer some kind of loans but not a license for other kind of loans?
Well, it's kind of the way the law has developed, and it's also because whenever you do license the lenders and put some restrictions on them, they'll try to shift to something else that's unlicensed. And that's why a lot of them are shifting. Years ago, when people called me about internet loans, nobody was doing open-end loans. Now I'd say it's probably greater than 50% because they know that they can get away with that. It's not that they want to make loans like that, it's just that they're shifting to try to get out from under the regulation. Mm-hmm. So that the law needs to change along with these practices and to go ahead and regulate that part of the industry as well. It doesn't make any sense to regulate part of the industry and not this other part.
And I think one other example of this kind of whack-a-mole that Jay has described was a lawsuit that our office recently filed against a company called Future Income Payments. They didn't even they tried to argue that they weren't even a lender. They said that they do sales of future income. So they targeted civil servants who had a pension and said, okay, well, if you have a pension, we'll give you a sale of your future income. And they restructured their repayments around their pension payments. So when there are defined terms, when there are these regulations, these lenders will try to come up with a way to say, we're not even a lender, we're this sale of future income, so we're something completely different. And it creates this problem of trying to keep up. And so open-end lending, for instance, wasn't nearly as widely used as it is now several years ago. But because we restricted payday, because we restricted car title, they've said, okay, well, we're going to go to open-end. They're unregulated.
So the Virginia Attorney General's office, unlike the General Assembly, the Virginia Attorney General has done what he is supposed to do, which is enforce the law. And they've done some great work, particularly in the last few years. They've gone after the internet lenders that are breaking our law. But they need to be given some more tools to go after some of these other folks who are also getting out from under regulation.
So, question from the audience to our two lending third parties over here, which is, who actually owns these loan companies? I recognize both of you, neither of you are actual lenders, you're both third parties. But the question from the audience is, who actually owns these lending companies? Who's making a profit? Is this American companies or these companies abroad?
So so as the marketing arm, we work with a handful of lenders that lend online. We're very strict because, without boring the heck out of you, we have our own brand. We have one brand, and we spend our own money to advertise that brand. So we match consumers with lenders. We want to make sure that the consumer has a good experience because we're the ones that are putting our brand out in front of it. So if you think of Expedia, when you use Expedia to book a travel, we're the conduit to line them up with lenders. So for us, we have very tough scrutiny for our lenders before we'll agree to work with them. Most of our lenders are actually state licensed, and most of them are offering more of an installment product that's state licensed in the states they do business. I would say that all of our lenders are U.S. based. Our lenders, 3 or 4 of them are publicly traded companies. We've got companies we've got everything from a small business in Delaware that will only do loans if we get an applicant from Delaware and he's licensed in Delaware. That's what he does. We have another lender who might be in 4 states in the Midwest. That's in just those states, licensed in those states. So, but we scrutinize any lender before we work with them because we want to protect our brand and we want to protect the consumer. That's why our consumers have had, and we've been in business 10 years, we've never had a consumer issue in 10 years. We've got an A rating with the Better Business Bureau. We don't sell data. We don't double sell leads. We don't do all the crap that lead generators and marketing companies tend to do. So we're very particular about who we work with. And our clients, I can speak for them because if I couldn't, I wouldn't partner with them.
And on the car side, it's a similar story. Almost all of them are U.S. based and state licensed. The exception actually being Santander was originally a European and Spanish bank that became licensed in the States and are now actually the captive lender for Chrysler America. But yeah.
Are they an outlier? Talk about Santander and like your thoughts about that.
I mean, Santander is a unique bank in a lot of senses. They've always been very deep subprime. They buy a lot of really unique things. Things that we've always said that there's a bank out there for someone who has something very specific. They think they found the secret sauce. Whether that's someone in a very particular situation of an open Chapter 7 or recently discharged Chapter 13, there are people who believe that those customers are going to pay them back, and yes, those interest rates are going to be higher. I mean, it's the balance of that delinquency rate versus non-payment that can be profitable and allowed under the law. But it's on the dealer's responsibility not to, using an industry term, bury that customer in a loan in which they won't be able to get out of because, again, in our business, it's beneficial for the customer to get out of that loan and purchase another car. An auto lender or an auto dealership doesn't make more money, or they shouldn't legally make more money off of a consumer who has less than perfect credit versus perfect credit. We sell the car at the listed internet price. We're required by law to do that, and you should always make sure that that happens at a dealership because some don't honor that law. But it's always beneficial for for them to get out of that loan.
Going back to your question about who owns these companies, there used to be a guy named Scott Tucker. Was that?
Yeah.
Who owned Cash Call, which was a big company that the Attorney General's office sued along with us, and he had a big company that's selling all around the country. He is now in prison along with his lawyer. Because their business was in evading state laws all around the country. And the other thing I'll say about who owns...
Wait, can you explain the trick to their evading the laws? Was this the company that pretended to have affiliations
Yes.
with Indian tribes?
Yes.
Yeah.
Right.
Yes.
Talk about that.
Yeah, and that's the other big trick is a lot of these companies, including at least 3 of the members, board of directors of the Online Lenders Alliance, pretend that they are making loans to an Indian tribe. And the reason they do that is because Indian tribes have sovereign immunity and you can't sue them. Only the problem is they really aren't being made through the Indian tribe. The Indian tribe is getting 1%, 2%. It's just a trick that they're playing to try to get around, again, to just evade the law.
So,
And
can I jump?
Go ahead.
I'm sorry. Scott Tucker, you talked about earlier, Cash Call was Paul Redham. That's a separate case. Scott Tucker was literally the guy that started this whole, quote, payday loan online thing out of Kansas City. You're absolutely right. Bad guy. Been in jail, his lawyer's in jail. He was not in jail for interest rates or violating anything regarding the loans. He's in jail for not disclosing, not proper disclosures, trying to collect on debt that wasn't there. Absolutely just brutal debt collection. After people had paid their loans in full, still taking money out of their account. I mean, this was a bad guy. He's absolutely in prison. Bad guy. So there's no doubt about that. The other guy, when you talk about the Online Lenders Alliance, some of the board, a couple members of the board, have created partnerships with sovereign nations. In the old days, it was considered rent-a-tribe. You tie into one of them, you give them just a percentage of your deal, and that's it. The federal government got very wise to that. If you look now at those companies, and I know some of those companies from being on as part of the OLA, the call centers are at the tribe, the processing is at the tribe, the actual, a very decent piece of the organization and operation is now through the tribes. It wasn't always like that. I think they've cleaned that up a bit.
Well, interestingly, the net credit case that's pending in Fairfax County, they don't affiliate themselves with a Native American tribe, but as I said in the beginning, they affiliate themselves with Utah because Utah has no cap on the interest rate. We did a lot of research on this company before we filed the lawsuit against them, and they're a member of the Online Lenders Alliance. They misrepresented that they were licensed by the Utah Department of Financial Institutions. Utah doesn't license these companies. They give them a registration, which is like a one-page form and a $100 fee. And NetCredit misrepresented, and our position is that they've misrepresented this relationship with Utah. They've said we're affiliated with Utah, we operate under their guidelines, we're regulated by their Department of Financial Institutions, and our position is they're a Chicago entity. They became a Utah entity after we sent them a notice of violation that said we think you're violating the law. I think the next day they said, oh, we're a Utah entity, so we're affiliated with Utah. So this affiliation with another state, with a Native American tribe is a common thread in lenders like this.
Yeah, I would agree with that. A couple things, and I don't think that case has been settled yet, so I'm not sure if the position of the state has been confirmed by a judge or a jury. But I guess the other thing is you're spot on with the internet. The internet is, even though there are bad people on the internet, the Wild Wild West, but even to this day, in all internet commerce, right? If I live in Alexandria, Virginia, and I buy something online from Amazon, or I buy something online or do some kind of internet commerce, is that commerce Virginia law? Or if I buy it from somewhere in Ohio, is it Ohio law? And so I think and you're 100% correct. The lenders, the online lenders, their goal is going to be, how do I figure out which of all these laws is the one that I say governs me? And I think that we're getting better, the overall industry, and I think the country, on figuring out internet commerce in terms of what laws and taxes and things apply. I don't think we're there yet, but I think it's getting better.
Yeah, NetCredit's an internet lender, and this is the Online
Right.
Lenders Alliance. So,
And Aaron just got a judge in Fairfax to rule that she is correct about these loans, right?
right. Yeah, the NetCredit filed a motion to dismiss our case, and one of the primary issues in this motion to dismiss was whether or not the Utah choice of law clause is enforceable. And the judge found in our favor. It's a preliminary ruling. It doesn't mean that we win, but the judge did find that the Utah choice of law clause is not enforceable, partly for the reasons that I've described, which is that they're not really truly affiliated with Utah to be able to use that state's laws.
Question from the audience about credit card companies. We've obviously been focused on online lenders and payday lenders and car title lenders. What about the credit card companies? Are they predatory? I mean, Jack, you actually sort of touched on this earlier. Like, why focus on some of this market and not the bigger picture, who are in parts, they're in every one of our wallets right now, right? What's in your wallet? Is it predatory?
Well, I think that's a great question. I mean, when you look at, and I think you had mentioned it earlier, Aaron, when the one lender was charging a fee, which in essence brought the interest rate over the legal boundary. It's kind of, being sneaky about it. And I think when you look at credit cards, it's the same type of deal. You get that payment in 1 day late, and they whack you for the full, the full percentage on your prior month's bill. Not just 1 day of an additional interest. They whack you for the late fee plus the insurance. Plus the interest from the prior month. So you could be 1 day late on a credit card on a $2,000 credit card bill, and you could be with a couple $100 charge. Also, if you pay the minimums month and month and month, you end up going, holy cow! I had a $1,400 credit card. I just paid the minimums, and X amount of years later, it cost me $5,000. So you figure. I think also, and I obviously, because I own a marketing company and some of my clients are in the space, I'm more sensitive to their concerns. But I also believe that the quote payday lenders or the corner, car title store, they're pretty easy targets. Everybody can rally around them, and I get that. It's hard to rally against Citibank. They got a lot of money.
I don't think Enova doesn't have a lot of money, but that's not the reason that we filed a lawsuit against them.
Oh, no, I'm not saying just
The
you
credit card
guys.
companies are regulated, and they're regulated by either, they're all affiliated with banks, and they're either regulated, if they're a national bank, they're federal regulators, and if they're a state bank, they're state regulators. And it's true that if you don't pay your balance in that grace period, they're going to charge you, 12%, maybe 20-some percent. But these other folks that we're talking about are charging 250%. And there's a world of difference between that, and they're not even given the grace period. So,
And credit card companies are required to give more disclosures under federal law, like on their billing statements every month. They have to include more information than an open-end lender does under Virginia law and under federal law.
yeah, in fact, what the open-end credit is basically it's a credit card on steroids. We had a case that Erin brought when she was in private practice. These two folks borrowed $2,500, and they paid on it for 4 years.
Yeah.
Paid, I think, $12,000. Guess how much they still owed? $2,500. And that's the way those. So it's a credit card on steroids with no regulation.
And additionally, back to your first initial point is they run credit checks and look at they set a credit limit and use that to determine their APR. They don't just, you can't just, submit a lead on Chase and they say, here's a $20,000 limit.
Question from the audience on the issue of APR. This person in the audience says the priority is not how to prevent the need, it's better management of the APR. So it's capped. So what needs to happen? I'll open this up to the panel. What needs to happen to course correct the APR?
General Assembly.
Yeah, I mean, we have, in Virginia, as Aaron said, we have a 12% usury cap. About 100 years ago, we had an exception passed called the Small Loan Act, which allowed, I think, about 18%, and over time that grew to 36%. It wasn't until 2002 that we started putting in all these exceptions for like the payday lenders, who can charge on average 250%, the car title lenders, and then we have these other folks who are not following the law at all. So a lot of states have gone to 36% cap. Colorado, in the last election cycle, they passed a statewide referendum to cap all loans at 36% with overwhelming, something like 68% of voters voted for that. Montana passed it a couple years ago. So 36% would be a reasonable cap that we could put over all these loans. And if you can't make money at 36%, you just don't have the right business model.
I agree with you in a lot of ways, but at some point there does need to be a discussion with the people making the loans versus what can be profitable. 36% seems very, very reasonable. I agree with you on that point because those APRs being as high as they are outrageous. But there are some states that have capped it so low that at least in the auto space, we've seen consumers start to drive out of state lines to try to purchase cars from us at a higher interest rate because the cars were more expensive in the states where they couldn't charge that higher interest rate. And it's I know it sounds it's upsetting to have that higher interest rate, but it's at some point it does protect the delinquencies and things like that are protecting the actual lender itself.
I think the way to get rid of high interest rates, which I think is a great idea, and I'm all for a 36% max. I think it's great. I think the way you get rid of the issues that you've been hearing about for the last hour and a half is have a way for the banks, the big banks, to figure out a need to serve this market. We still have not, you can't, well, I don't know this, I'm not a lender. I would assume you can't make money lending less than $1,000 at 36% if it's unsecured, meaning the person, you don't even run credit checks. There's not even credit checks. I mean, the person could take the money and walk away. I'm guessing. I don't know. I haven't crunched the numbers. But I think the way that, and we're all in agreement, I think the lower interest rate, the better for the consumer, the better for our fellow American, our fellow Alexandrian. They can do more great things. We're all in favor of that. But until we figure out a way for a Wells Fargo and Chase and all the other banks around to be able to help that consumer, then you're going to have these stores and these online lenders because there's a need there. I mean, and I think that there was even talk at one point upon the government, someone up on Capitol Hill had an idea to have the post office facilitate these type of loans. You know, I mean, they're $2 billion in debt, but hey, give them a shot. I mean, there's got to be something, there's got to be another option. I don't think anybody disagrees with that. And that's what we haven't spent any time talking about is there's got to be a better way for these consumers. There's got to be.
I'd also slightly disagree with the premise of the question in the sense that education is not a problem. I don't think that. I think there's a reason why Mrs. King's business exists. That a majority of the population is, financially illiterate. If you're financial literacy, people don't leave high school or middle school understanding these terms. All the terms that we've been throwing around today, they're difficult. They're hard. A lot of people have to be experts in this stuff, and it doesn't make sense. I mean, unless you were lucky enough to have a parent who, I was lucky enough to grow up in this business. I understood what LTVs and APRs were when I was, 10, because I would see this commercial and say that doesn't make any sense at that age. And how does that make sense? And he would explain it to me. But that's not the case for a lot of people. They don't understand how credit cards really work, how minimum balances work, how when you're charging interest rate, when you're not charging interest rate. There's stuff like that should be taught at a younger age throughout any public school, private school, doesn't matter. People should leave understanding how to balance a checkbook, what a credit score means, how it's calculated, what are the factors that go into it, and how you can edit it.
I agree. I'd like to ask you a question. All right, subprime, big subprime car dealer, the best around. I would ask, tell me who a typical consumer is. Because I know when I see the leads that come through our system, and you think of who is online applying for a loan, an unsecured loan. I know for us, you get school teachers, you get nurses, you get people that work for Verizon, you get people that are making $60,000, $70,000 plus. And I want to know who's in the I bet it's not what people think it is.
Yeah, I mean, I would agree. I mean, yeah, it's half the United States population is what some people would consider subprime, if not 40%. The last time I checked it, it's everyday people. It's good things happen to bad people. That's something we always say to our staff when they're first getting into it. Don't look at someone with a low beacon as lesser, or that they've done something wrong. It could be something as simple as getting a divorce and getting sick. It could be a million things that could happen to that person. But it doesn't mean that they're a bad person at all. And that's where a lot of this stuff comes into. But at the same time, it doesn't necessarily open them up to say you can just charge them whatever you want. That's not at all what I don't think anyone up here is trying to say. But yeah, they're average people. It's average income. They're just people.
Yeah, that's right.
Another question from the audience. Members of the military. Are members of the military banned from getting payday loans? There are special restrictions here that only apply to members of the military and their families that do not apply to most people, right? Jay, talk a little bit about protections, and then you can. So what protections exist for members of the military and their family?
Under the Federal Military Lending Act, loans are capped at 36% to active duty military. The reason for that is that, first of all, the predatory lenders love the military. If you go to an Army base, you'll see a lot of these places right around the gates to the base, And that's because they tend to be younger men and women that are not all that sophisticated. If you don't pay the loan back, then they threaten to contact your commanding officer. But also probably the main thing that caused Congress to pass that 36% cap is when you get a military person in trouble, it messes up their security clearance. And now you've trained somebody for a long time to be a good member of the military and got them through their security clearance. And when they get into debt trouble, then you're gonna lose that person. And it ends up costing all the taxpayers more money to train more military. So that's why that cap is in there. But it's only active duty military.
Yeah, we've been in business for a while, and we've worked with our lenders, and we've never once had a lender that would loan to the military because of the rate cap. So yeah, so that's real, and it's been there as long as I can remember.
So I also wanted to touch on the topic of availability of information. This is something that I always sort of think about, is what kind of information is available to me? What's public information? We have a new directory I strongly encourage you to pick up that has a ton of public information. Did several public records requests to get them. But if you make a public records request for the annual report that's submitted to state regulators by LoanMax or TitleMax, you will not be able to get that annual report. They submit it to state regulators, it's state property, but you cannot get it from the state corporation commission. Aaron, talk about your efforts before you joined the Attorney General's office to get those documents.
So I need to make a very clear distinction here that this did not happen while I was at the AG's office. This happened while I was in private practice. That being said, I represented a company who tried to get these reports. And like I said before, open-end lenders don't have to do this, but Payday, Car Title, these lenders do have to submit these annual reports. And it's really interesting because they talk a lot about their business and exactly what they do. They have to say whether they've been sued by somebody. They have to say if they've paid a judgment. They have to say if they've obtained a judgment against a consumer. Lots of information that should be publicly available by these entities that are regulated by the Bureau of Financial Institutions. But the Bureau of Financial Institutions feels very differently. They have instructions on their website to these companies when they make the reports that say these are private, they're confidential, you can provide them to us and we don't disclose them. So we filed a lawsuit because we disagreed with that. We initially started with like an administrative hearing at the State Corporation Commission and argued that the law, not just the Bureau of Financial Institutions website, provided otherwise. The law gave no special protection to these reports filed by car title lenders. The SEC disagreed and said that they should be kept confidential. So we appealed that to the Virginia Supreme Court. Scott Suravel was my employer at the time, and he thankfully took over that case when I moved to the AG's office, but he was not successful with the appeal, primarily because of something I did when I had the case. So I'm being a little self-deprecating, but yeah, so those reports are not public, and you can't get them. And until there has been some legislation that was introduced for the past 2 years simply to say that these reports are public, and from going forward, when car title lenders, payday lenders file these reports, they should have the expectation that someone can get a copy of it if they want to see it. That legislation has not passed. While I was at the AG's office, we did support that legislation to make these public, but unfortunately that hasn't really gone anywhere.
Any thoughts on that? Okay, so we sadly are coming to a close, near a close, but I want to go around the panel here and get a sense from our panelists about sort of what is crystallizing the discussion, if you could, to say what is the problem, if you could identify one key problem, and then what's the solution, right? So what is the problem we should be focused on? And Jack, I heard you talk about this a couple times. What is the solution what is the problem we should be focused on? And then what is the solution to that problem? Jack, I'll start with you.
I think the problem is there is a huge need for this product. If there wasn't, all these businesses wouldn't be in business. And I think that we've got to find a way to make access to credit more available to these folks that don't have great credit. So we got to figure it out. I don't know that putting a hard rate cap on it is a way to get it done. I think sitting down with leaders on both sides and going, look, what really makes sense? Let's take our books out. Can I make money at this rate? Is that fair to the consumer at this rate? Are the disclosures properly done so the consumer understands what they are doing? It's very important. And I think that we don't give the consumers a lot of credit in terms of understanding the deal that they're getting into. So I think that we've got to come together, figure out a way to make it better for everybody. I think also on the small dollar loans, the percentages, they sound out of whack. It sounds really bad. I know a couple months ago, I got a parking ticket in Alexandria. It was 35 bucks. After 2 weeks, I didn't pay it. It went to 70. I was like, that's 1,200%. I was like, they're predators. But anyway, I think we have common ground here. I think we all want a better life for the consumers, and more importantly, access to credit that they can afford.
I would say that the problem stems from the fact that it doesn't feel, when you look at the numbers, that a lot of these lending partners are issuing these loans with the intent of recovering the loan value. They're not designed specifically for the consumer to get out of the cycle. And so if that's going to be the practice, to me, that's the definition of predatory. And so figuring out a way of determining a factor, like almost like a fiduciary responsibility from the loaning partner, to say that they're required to say that I believe that this person can do this, and this is why, and these are the numbers that I have to back out on the research that we have done. I think that's important. I think teaching just people growing up how finance works just in general, even at its most basic levels, is important. And I think another thing that could be beneficial, some ideas I've heard floated around, were the idea of employers of a certain size being required to offer a pay advance at a certain number of times a year, maybe, let's say 3 or 4 times a year. An employee has a legal right to request an advance on their paycheck at a 0% interest rate, and then they get that paid back on the next paycheck.
So I think on a broader scale, I don't disagree that the problem is that there is a need for people to have some more money. I think that we can all agree that that's a problem. But Virginia specifically, what I see as the problem is inconsistency in the laws that apply to the players in this atmosphere. There are loopholes that need to be closed. The legislature needs to put everyone on the same playing field. There's loopholes in the forms of certain types of loans. There's loopholes in saying that certain lenders can choose another state's law. We need to put these lenders on an even playing field and focus on the need for the consumer, not the profit to the companies offering the loans.
So remember, Virginia's had usury laws since before the Declaration of Independence. I mean, this has always been a problem, and there's always going to be usury out there, and we have to properly regulate. In the short term, we have to properly regulate and stop passing all these exceptions to the usury law, go back to where we were, where we had a usury cap, and regulate the companies that make these loans. Otherwise, they will exploit people who need money. And I would also go back to the ability to repay is key. If you are not assessing the borrower's ability to repay, you are loan sharking. That is the difference. The Consumer Financial Protection Bureau, under its previous director, Richard Cordray, studied small dollar loans for almost 2 years, interviewed thousands of people, had forums all around the country, took in thousands of comments, put together, I think, an 800-page report, and the key to that was, they said the key to this is the ability to repay. If you are making loans only based upon whether you can collect from the person by taking their car or taking their paycheck or taking money out of their bank account, you are not lending, you are loan sharking, and we don't need that. Unfortunately, that rule is never going to go into play, because the current director of the Consumer Financial Protection Bureau is going to kill it. He's doing it in a slow motion way, but that's what's going to happen. So, but I think the ability to repay and going back to our usury laws that have worked for us for hundreds of years is the way to go.
So that brings us to the end of our evening. I want to make a quick commercial for the January meeting of Agenda Alexandria, which will be back here at the Hermitage, where we will talk about school security and bullying in the classroom. So please join us in January for that. And I'd like for everyone to give our panel a round of applause. Thank you so much.